Good morning. The court is going to take up the next case on the court's docket. It's C190087 CPS. This is in the interest of London Anthony Jones, a child. The case is set for a bench trial today. The hearing is being conducted pursuant to emergency orders of the Texas Supreme Court via Zoom video conference. Participating in the hearing today on behalf of the department is caseworker Lisa Loman and Regional Attorney Jason Jett. The mother of the child is Crystal Jones, who has executed an affidavit of voluntary relinquishment of parental rights that's on file with the court. Ms. Jones is present. The father of the child is Jason Jones, who's also executed an affidavit of voluntary relinquishment of parental rights on file with the court. Mr. Jones is not present. Brad Harrelson is present as the attorney ad litem for the child and has also filed a statement with the court. The CASA guardian ad litem representatives for the child are James Valentino and Jordan House, both of whom are participating in the hearing today. And they have also filed a report with the court. The child that is the subject of the suit is excused from participating in the trial today. As I noted, this case is set for a bench trial today. Mr. Jett, is the department ready to proceed?
Yes, Your Honor. We're ready to proceed.
And Mr. Harrelson, are you ready to proceed?
Yes, Your Honor.
Okay, Ms. Jones, since you're representing yourself, are you ready to proceed?
Yes, sir.
Okay, thank you. Mr. Valentino, Mr. House, y'all are ready?
Yes, Your Honor.
Your Honor, we are.
All right, thank you. All right, any openings in the department?
Just briefly, Your Honor, we're here for a final, as you noted. There are affidavits of relinquishment, which you also noted. I think we're going to be asking for termination of parental rights today for both parents, and then move on. My understanding is that that may not be everyone's position here, and just in order to cover all the bases, we may be asking a few questions about things like child support in case Your Honor doesn't terminate rights. So, but we are asking for termination of rights at this time. Thank you.
And thank you, Mr. Harrelson. Any opening statement?
Your Honor, I've been with London, if you will, as attorney-client since situations began in the juvenile system back in when he was about 12. So I've known London for a long time, and London's situation is difficult. And I will convey to the court what London's desires are at this time, and I will leave best interest determinations or recommendation and determination to the parties who are appearing in that capacity.
Thank you. And Ms. Jones, you're not required to make any opening statement as to your position, but if there's something you'd like to state, you'll be given an opportunity later if you wish to testify. Do you have any opening statement?
No, Your Honor.
Okay. And Mr. Valentino and Mr. House, as we proceed through the trial, I'll arrange the time for you, if you're not otherwise called as a witness, to testify as any recommendations you have relating to the child. Okay.
Yes, sir. So we have shared the position for termination of parental rights. Mr. and Mrs. Jones have both signed their voluntary relinquishments of rights, and interaction with London and the family has been a known trigger for his regressive and abusive behavior. And I know that Mr. Harrelson had submitted a statement to the court this morning where that may not be what London desires to be, but that is CASA's position as well.
We'll give you an opportunity to testify more fully as to that as we go forward. All right, I'm going to ask, let's see, Ms. Loman, Ms. Jones, Mr. Valentino and Mr. House. If each of you could raise your right hands, please. Each of you solemnly swear or affirm any testimony you give today before the court will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
Yes, sir.
Thank you. All right, Mr. Jett, if you're ready to proceed with your first witness.
Yes, Your Honor. At some point, I will be asking the court for permission to share my screen to publish to Ms. Loman some documents, but would ask for the technical permission right now.
I've enabled that so that'll be available when you're ready to proceed.
Thank you, Your Honor. I would like to call Ms. Loman.
Thank you.
Please state your name for the record.
Lisa Loman.
And Ms. Loman, how are you employed?
I am a caseworker with CPS.
Okay. And are you assigned to London Jones and his family?
Yes, sir, I am.
Where is London currently placed?
London was moved to Hands of Healing in Baytown, Texas. That is a residential treatment center.
Okay. And how long has he been there?
He was moved on June 19th.
Okay. So just about a month there then.
Yes, sir.
Okay. Are we here today to ask for the termination of parental rights of parents?
Yes, sir.
Has each parent signed an affidavit of relinquishment?
Yes, sir, they have.
Your Honor, this time I would like permission to share my screen.
I think so.
Thank you. Ms. Loman, do you recognize this document here that's marked as Petitioner's Exhibit 1?
Yes, sir.
Okay. And have you seen documents like it before?
Yes, sir.
Okay. And is this, and what is this in general terms?
This is the Court of Continuing Jurisdiction.
Okay. And is this particular one for London Jones?
Yes, sir, it is.
Okay. And is it a certified copy of that document?
Yes, sir, it is.
Okay. Your Honor, this time I move to admit Petitioner's Exhibit 1, Court of Continuing Jurisdiction documentation for London Jones.
All right, any objection to petitioner exhibit number 1?
No, Your Honor.
No objection being heard. Petitioner exhibit number 1 is made.
Thank you, Your Honor. All right, turning your attention to Petitioner's Exhibit 2, Ms. Loman, do you see that on my screen?
Yes, sir, I do.
Okay, and have you seen this document before?
Yes, sir.
Okay. Is it, in fact, does it bear your signature as well?
Yes, sir, it does.
Okay. And is it a certified copy of this document?
Yes, sir.
And what is this document, please?
This is the affidavit of relinquishment for Jason Jones.
Okay. And is it as to the child London Jones?
Yes, sir, it is.
Okay. Move to admit Petitioner's Exhibit 2, Your Honor, the affidavit of relinquishment of Jason Jones as to his child London Jones.
Any objection?
No, Your Honor.
No objection being heard. Petitioner exhibit number 2 is admitted.
Thank you, Your Honor. Ms. Loman, is this affidavit signed by Mr. Jones?
Yes, sir, it is.
Signed by 2 witnesses?
Yes, sir.
And is it also notarized as well?
Yes, sir.
Are you asking the court to accept this relinquishment of Jason Jones's right as to his child, London?
Yes, sir.
Moving on to Petitioner's Exhibit 3, do you see that on my screen, on your screen?
Yes, I do.
Okay. And what is this, please?
This is the affidavit of relinquishment for Crystal Jones in regards to London Jones.
And is it significantly similar to the document we just talked about in Petitioner's Exhibit 2?
Yes, sir.
It's signed by Ms. Jones,
Yes.
signed by 2 witnesses,
Yes.
notarized,
Yes.
and is signed by you accepting on behalf of the department?
Yes, sir.
And is this a notarized copy, or excuse me, a certified copy of this document?
Yes, sir, it is.
Move to admit Petitioner's Exhibit 3, Your Honor, which is affidavit of relinquishment of Crystal Jones as to the child London Jones.
Any objection, petitioner exhibit number 3?
No, Your Honor.
Petitioner exhibit number 3 is admitted.
Thank you, Your Honor. Ms. Loman, are we asking the court to accept the mother's affidavit of relinquishment as to London Jones?
Yes, sir, we are.
Is the termination of parental rights in this child's best interest?
Yes, sir, I believe it is.
And can you tell us why?
London has been through a significant amount of trauma. As Mr. Harrelson said, I do feel that London is often triggered by his parents, but I don't feel that he should have no contact with his parents. I feel like he should have contact as deemed appropriate by his therapist at his current placement.
Is there someone or some situation better for raising London than his parents currently?
We don't have any family members identified, and currently he's at the residential treatment center. We believe that he needs to continue with treatment because he still has the behaviors that he had at the beginning of the case. He is doing well so far in his residential treatment center. I believe he's only had 1 incident since he's been there. I know it's only been a month, but at this time we don't have any family identified for adoption of London.
And does it appear that he might be in treatment long term based on what you can determine now?
I would think that he would probably need to be in treatment long term. I'm guessing maybe 6 months or more.
And has he been in treatment? How long has he been in treatment?
He's been in multiple residential treatment centers, 3 since I've had the case. His last one, he was there for over a year. And then this one, he's been in a month. And then the previous one shut down and he was only there for a few months, I believe. So he's been in treatment in a significant amount of time throughout this case.
Has London discussed with you his desires about what should happen?
The last discussion I had with, I'm sorry, you cut out and I couldn't hear all of what you said.
I'm sorry. What's your understanding from talking to London about what he wants concerning his parents' rights?
The last conversation I had with London was when he was still here in San Angelo. And he said that he wanted to continue to have phone contact with his mother. I asked him if he wanted visitations with his mother, and he said at this time he only wanted phone contact and he didn't want in-person visitations. I did tell him that they had relinquished and that we were going to terminate their rights. At that time, he was fine with it. But apparently Mr. Harrelson has spoken with him since and he has changed his mind.
All right. If the parents' rights are not terminated today, should they pay child support?
Yes, I believe they should, yes.
All right. Ms. Loman, I think that's all I have for now, unless there's anything that you would like to add about this child or this family.
No, I don't think so. Not at this time.
Thank you, Your Honor. I'd like to pass pass Ms. Loman.
Mr. Harrelson, do you have any questions for Ms. Loman?
Yes, Your Honor. Thank you. Ms. Loman, is London's current placement considered a long-term placement?
No, I think it's just a temporary residential treatment center.
So going forward, is London in a program that the intent is that he eventually completes?
Yes, sir.
All right, and then assuming he completes his stay there at Healing Hands, what's next for London?
As I stated previously, we don't have any options for London at this time, but the department will continue to seek an intended to be permanent placement for London.
Do you ever see reunification as an option that would be in London's best interest?
I believe that maybe longer into the future that London would probably be able to be reunified with his parents. I feel like that is not in his best interest at this time, but maybe after treatment and he gets better, that might be an option down the road, yes.
Okay, now reunification has been tried before, correct?
Yes, it has.
And was that on a monitored return?
Yes, sir, it was.
And how long did that last before it fell apart, for lack of a better term?
A few months.
Okay. And did that, what was the precipitating event, the deciding factor that made it fall apart?
London assaulted his mother again and was arrested and sent to juvenile detention.
Thank you. I'll pass the witness, Your Honor.
Ms. Jones, you're not required to ask any questions of this witness, but if you have any questions regarding her testimony, this would be your opportunity to do so. I'll give you an opportunity later if you want to testify on your own behalf. Any
No,
questions? All right, thank you. All right, Mr. Jett, did you have any additional questions for?
No, Your Honor, not for Ms. Loman at this time.
Okay. You have another witness you want to call?
Yes, Your Honor, I'd like to call Ms. Jones.
All right, Ms. Jones, I believe you were previously sworn in, so you remain under oath. Right, go ahead.
Thank you, Your Honor. Ms. Jones, my name is Jason Jett. I believe we met once before at the very beginning of this case. I do represent DFPS CPS. I know this is very difficult, and I will do my very best to not make this overly personal or overly difficult, but this is a very sensitive and serious situation, so I must ask some questions that might be both serious and sensitive. I want you to know that I take no pleasure in that. First of all, please state your name for the record.
Crystal Jones?
And Ms. Jones, are you the mother of London Jones?
Yes.
Ms. Jones, you've filed an affidavit of relinquishment, and it's been introduced as an exhibit in this trial. You're familiar with that affidavit, correct?
Yes, sir.
Are you still asking the court to accept that affidavit of relinquishment of your rights to your son?
Yes.
Do you believe that's in his best interest?
Yes.
Why?
Because we've tried several times to bring him home, and it's a safety concern for the other children in the home. And I don't know that he's ready to be home.
Is there a possibility in your mind that he could be ready to come home at some point?
I'm not sure. This was our second joint managing conservatorship, not the first. So, and this has been going on for a course of a few years. So, I mean, I'm not sure. Possibly down the line, but not anytime soon.
Okay. How many other children are in your home?
3.
And what are their ages?
I'm sorry, why does this matter?
Ma'am, I apologize, but I'm going to have to instruct you to answer the question, please.
Okay. 6, 7, and 14, but they're not in the case.
And have you had any other cases with CPS with any of those children?
No.
Ma'am, do you work?
No.
Does Mr. Jones work?
Yes.
And the two of you are together as a married couple. Is that accurate? Yeah. What is his annual income or monthly income?
It varies on the hours, but usually it's about $1,300 a week.
Okay. All right.
Sometimes more. That's not his take home, but that's the gross.
That's the gross. Okay. I'm sorry, do either of you have any other children other than the 3 that live with you in London? Other than those 4 children, do either you or Mr. Jones have any other children?
No.
There has been some discussion about continued contact with London. What's your opinion about continued contact with London after this hearing today?
That's one of the reasons I agreed to sign over my rights, was because I was told that I would be able to continue contact with him. And I did ask that I would be able to continue contact with him through phone calls or even visitations.
Okay. Do you believe that visitation is in London's best interest?
I guess I would be up to his therapist.
And other than Mr. Jones' $1,300 a week income, gross income, does your family have any other sources of income?
Other than just my crafting that I do. I mean, I make money that way from home, but that's it.
Okay. And what would you think that in an average month that your crafting income provides your family?
400.
All right. I believe that's all the questions I have for Ms. Jones right now, Your Honor. I believe I'd like to pass the witness.
Mr. Harrelson, any questions?
Yes, Your Honor. Thank you. Crystal, have you spoken with London since he's been placed at Healing Hands?
Yes.
How many times?
Once.
And how was that phone call? Who set that phone call up?
Lisa.
Okay. And how would you describe the call? Was it, do you believe it was good for London to speak with you?
Yes. I mean, I feel like our phone call was very pleasant. It was an enjoyable phone call. Normally, any of the other calls we got in the past previously, they would be maybe 5 to 15 minutes. I got to speak to him for about 30 almost. And he did tell me everything he's been doing. He asked me for some packages that he's been, expecting from Lisa. But other than that, he just told me that they do activities pretty much all day and said that he's doing pretty good over there. And he just asked me how things were going over here.
Okay.
It was a very pleasant phone call.
Are you aware, was there, after that phone call, are you aware of any negative reaction that London had with regard to acting out or anything like that?
Not that I'm aware of. No, sir.
And do you have another phone call scheduled?
There wasn't a set day. I just know he said that he gets phone calls on Thursdays. I think that's what he said.
Okay.
So once a week, I believe.
Right. And are you relying on Miss Loman and CPS to arrange those phone calls?
I don't know how it's supposed to go. But I did ask Lisa because I had no phone call. I hadn't been able to speak to him in a while since he left juvenile detention. So I did ask her when I'd be able to receive my calls. So I don't know if she needs to set him up, but she did put me on his call list.
Okay. Well,
That's how the call start. That's how I got that phone call.
and I believe the situation now, since the department has managing conservatorship, that all of that would need to be coordinated through Lisa. Do you understand that?
Okay.
That's all I have, Your Honor.
Ms. Jones, any additional testimony you want to offer about the case?
No, sir.
Thank you. Mr. Jett, any other witnesses?
Yes, Your Honor, I'd like to call CASA. I'm not sure if it's Mr. Valencano or Mr. House that would be more appropriate.
Okay, Mr. Valencano, Mr. House, who would y'all like to have testify as to CASA's position on the case today?
Your Honor, I can speak towards CASA's position. If any of the questions are related to interaction with London and things like that, as the volunteer, Mr. House would have more experience towards that.
All right, well, Mr. Jett, I suggest you call Mr. Valencano first and then call Mr. House and give him an opportunity to testify anything you might want to add to it, just so they have a chance to cover that. Thank you.
Thank you. I would like to call Mr. Valencano. Please state your name for the record.
James Valencano.
And Mr. Valencano, how are you associated with this case?
I am the case manager for CASA at the Children's Advocacy Center.
Okay. And how are you familiar with the affidavits of relinquishment from Mr. and Mrs. Jones in this case?
Yes, sir. Those were submitted prior to me taking on the case, but I have reviewed them.
Okay. And they've been entered as petitioner's exhibits 2 and 3. And we're asking the court today to accept those relinquishments. Is that CASA's position as well?
Yes, sir, it is.
Do you believe that it is in London's best interest for the rights of the parents to be terminated?
Yes, sir, we do.
Why is it in London's best interest?
Because there has been a history of known aggressive behavior, and it is usually triggered whenever he has interaction with his family, and more specifically, his mother.
Do you believe that they cannot care for him now or in the future?
I'm not so much sure if they're capable of caring for him, but I just do know that the behavior that he has exhibited whenever he is away from them is significantly improved and better than the behavior he exhibits when he is with them in their care.
Does that present a safety concern for him in the home?
Yes, sir, it does.
Does it present a safety concern for others in the home?
It would appear so, yes, sir.
How old is London currently?
13.
If the parental rights were terminated, it might be a long time for him to be in the conservatorship of the department. Are you aware of that?
Yes, sir, we are.
And still knowing that, does that seem like it's in London's best interest?
We would believe so, yes, sir. He's receiving better care in the positions the placements he is in.
In your opinion, is this treatment center he's in the least restrictive environment?
Yes, sir. And he has also expressed that he prefers to be in an environment like that because he does appreciate the structure and the routine that comes with it.
If the court were to terminate parental rights today, should the parents be allowed to have contact after the termination?
Yes, sir, we believe they should. And CASA is happy that London wants to participate in that interaction with his family. Of course, we would prefer that it is supervised, as previously stated, through his counselor and his therapist. That way we have an opportunity to process those feelings that London may have about that contact.
If the court were not to terminate the rights today, do you think that the parents should be ordered to pay child support?
Yes, sir, we should. They should.
Is there anything else you'd like to add about London or this family or this situation?
No, sir, not from my perspective.
Your Honor, I believe that's all I have for Mr. Valancano right now. Thank you, Mr. Valancano. And Your Honor, I'd like to pass the witness.
You, Mr. Harrelson, any questions?
No, Your Honor.
Okay, and Ms. Jones, again, you're not required to ask any questions, but if you have any questions you want to ask.
No, sir.
All right, thank you. All right, Mr. Jett, would you mind calling Mr. House next and just to see if he has anything he wants to offer this morning?
That'd be fine, Your Honor. Call Mr. House.
Let me back up just a second. Mr. Valancano, was there anything else you didn't get to say that you wanted to say?
No, sir. I believe that between us and the department, our position has been stated. Thank you.
Okay, thank you. I'm sorry, Mr. Jett, go ahead.
I would like to call Mr. House.
All right, thank you. Go ahead.
Mr. House, you've heard the testimony here today in CASA's position. Do you think this termination is in London's best interest?
I do. Mm-hmm.
You're familiar with the statement that Mr. Harrelson has filed with the court indicating, first of all, Your Honor, I'd ask the court to take judicial notice of Mr. Harrelson's statement that he filed. I'm sorry, I don't know what he filed, but it was a statement about London's position.
Is there any objection in court taking judicial notice of that statement, Mr. Harrelson?
No, Your Honor.
Okay. Court will take judicial notice of the contents of that statement as a statement of Mr. Harrelson's position in the case. Thank you.
Thank you, Your Honor. Mr. House, are you familiar with Mr. Harrelson's statement of London's position?
The recent one that was just filed yesterday, I read it this morning.
Okay. Given that, do you still think it's in London's best interest to terminate the parents' right?
Yes, sir, I do.
Is there anything else that you would like to add about this child, this family, this situation right now?
Yes, sir. So I reach out to him on a weekly basis at his residential treatment center, um, just to maintain that contact, that point of reference, things along those lines. He is doing well there. I will reiterate what Mr. Valancano said about he does enjoy and is benefiting from the routine and the structure. It does sound as though he is making friends slowly but surely with some of the other boys living there. He does. They do keep him very busy. So I reach out to him weekly. I've talked to him at least several times since he's been placed there. And there's been a few times I've reached out and have not gotten a hold of him because they're on outings, trips, things like that. So physically, it sounds like it's a good placement for him. I did speak to him regarding continued contact with his parents. I did not speak to him about details regarding the termination of rights, but I did speak to him regarding contact, and he did just this morning actually reiterate that he does wish to maintain periodic contact, at least by phone, with his parents on a regular basis.
Thank you, Mr. House. I appreciate that. Your Honor, I believe that's all I have for Mr. House. Absolutely.
All right, thank you, Mr. Harrelson. Any questions?
No, Your Honor.
And Ms. Jones, any questions?
No, Your Honor.
Thank you. All right, Mr. You had any other witnesses?
No, Your Honor, I don't believe there's anybody else that I can call at this time. Thank you, Department of that.
All right, Mr. Harrelson, any other witnesses?
No, Your Honor. I rest.
Okay. And Ms. Jones, any other testimony you want to offer?
No, sir.
Okay. All right, all parties rest and close. All right, Mr. Jett, any closing?
I'm going to waive my right to open and reserve my right to close.
Mr. Harrelson, any closing?
Yes, Your Honor. Thank you. First and foremost, Ms. Loman, Mr. Valancano, and Mr. House, to the extent they have been a part of this case, have done, made an incredible effort, and I think really went, it may be above and beyond from what's usually done, but you know, it's what I think could be done for every kid, and time constraints a lot of times don't allow that because of workload, but they have made the time for London, and London's parents have been involved from the very beginning as well. London just is a difficult child, and I do not contest any of the testimony that you've heard today with regard to events, facts, statements made by London in the past, and his feelings one way or the other. What I can do is just convey to the court London's feelings as they were yesterday, which if given a choice, he would not ask that his parents' parental rights be terminated. I can tell you London understands the situation and knows that is before the court. Most important to London is that he be allowed to have continued contact, especially with his mother, who's that's important to him, and I'll leave best interest up to CASA and the department.
All right, thank you. Mr. Jett, anything else?
Your Honor, just briefly, this is a very difficult situation, very sad situation. We're asking the court to terminate the parents' rights based on their relinquishment. Yeah. I don't believe the department really takes a position on the post-termination contact, other than to say that I'm sure we're all aware of some changes coming September 1 about children whose rights are terminated, and then the ability of the parents to reinstate those rights, for lack of a better way to put that. Child's 13 years old, and that's 5 years is a long time until he ages out. And so to cut off that contact might be premature. I'm also aware, Your Honor, that when a 13-year-old child says, I don't want my rights terminated, that has to be taken into serious consideration by Your Honor. If that's the case, then absolutely you can't cut off contact. But we would then be asking the parents to pay child support for the care of their child. And it looks like the household income is between $5,000 and $5,500 a month. We'd ask you to base the support on one child in court, 3 children out of court. I guess you'd have to tax that against Mr. Jones, but for the family, because Ms. Jones says she doesn't have any actual verifiable income other than looks like a cottage industry that she does. So we think that would be important for the, whatever I'm sorry, I don't have the chart in front of me right now for 3 out, 1 in for child support at that rate. But we would ask for the child support if Your Honor doesn't terminate the rights. We do believe that that's going to be in the child's best interest. It does look like there's long-term need for some sort of, I try to choose my words carefully when I say these things, but some sort of institutionalization. And I know that that word has such a negative and awful connotation, but he's got to be somewhere. So we ask that you terminate the rights, name the department as managing conservator, allow the post-termination contact. If you don't terminate the rights, then to do all of the above and add child support on the hopes that this young man can come back to his family. Thank you.
All right. Thank you. Well, I would agree with everybody else who said this is a difficult case. A lot of the cases we have are difficult. This one particularly difficult given the circumstances and the child's age and how we got to this point. And I don't know what the future will hold for London. And I take no exception to the use of the term institutionalization of him, except for the fact that that was definitely not what the court's going to want to see happen with him. It may be that he needs to remain in some facilities for a while to receive treatment, but I'm hoping over time he can progress where he can be back in a home with someone, whether it's with his parents or with someone else. Hopefully that'll happen in his future before he turns 18. Regarding the termination, I'll make my findings and orders about that in a minute, but I want to make clear what I'm trying to do is keep options open. But I'm also trying to take precautions that do not preclude options. And so while my orders are going to include some post-termination contact, there's going to be some limits and restrictions on those and monitoring of that by the court going forward in a case, because I could foresee circumstances under which continuing that would not be in his interest if another viable placement was found, because we had one may or may not have worked out. There wasn't evidence about that, but I know it's in the CASA report that did not work out. I'm not faulting anybody for that not working out, but I think putting Lundy in a home where you're trying to work on that and continuing a relationship with his parents at that point might be counterproductive. I'm not saying it would be or it wouldn't be, but I want to keep the option open that the court can shut that off, or the department can shut that off if it is necessary to try to make sure that any attempt to reunify him with some other family is not undone because of his feelings about his biological family at this point. Again, I'm not saying that the court would preclude that, but my orders are going to include provisions where the court could stop that if necessary to allow that. Similarly, I'm not ruling out that somewhere down the line that this child might get in a position where being back with his family, parents, could be in his interest. It's clear to me right now that's not in his interest. This has been going on for several years. The initial case started back in 2016. And so we're kind of in the same point we were several years ago. I think everybody's trying to make an effort to avoid being there, but that we are where we are. And so at this point, the court feels like I need to put some orders in place to increase our options for other opportunities for him beyond his biological family and see how we proceed. Ms. Jones, I know this has been a difficult decision for you and your family. I appreciate that. I certainly take no pleasure in terminating any parent's parental rights, particularly in your situation. But I think I understand the decision you and your family have made, and I appreciate that. And I appreciate your interest in London going forward. And hopefully things for him and you can work out in the future. All right, with that, if y'all stand by for just a minute.
Yes.
All right, the court, after hearing the evidence presented and after taking judicial notice of the court's file to the extent permitted by law and after, and as noted on the record, and after hearing the position of the attorney ad litem and the recommendations of the guardian ad litem for the child, the court is going to make the following findings and the following orders under Chapter 201 of the Texas Family Code. Court finds that a request for identification of a court of continuing jurisdiction has been made as required by law, and though the court has continuing exclusive jurisdiction of the child, the subject of this suit, and this court has jurisdiction over this action. The court finds that all parties entitled to notice have been notified. The court finds that there's been a material and substantial change of circumstances of the child and the respondents since entry of prior orders relating to the child. And the court finds it would be in the best interest of the child for the court to modify those prior orders. The court finds that any presumption that the respondent should be appointed as a managing conservator or as a possessory conservator of the child is rebutted, that the appointment of the respondents as a managing conservator or possessory conservator of the child would not be in the best interest of the child because such appointment would significantly impair the child's physical health and emotional development. The court finds by clear and convincing evidence that the respondent parents have each knowingly and voluntarily executed after the suit was filed affidavits of voluntary relinquishment of parental rights to the department, relinquishing their parental rights to the child pursuant to and in accordance with the provisions of Section 161.001B1K and 161.103 Texas Family Code. The court further finds by clear and convincing evidence that the termination of the respondent parents' parental rights pursuant to those sections and Section 161.002B2 of the Texas Family Code is in the best interest of the child. The court finds that it would not be in the best, the court finds by clear and convincing evidence that the court's findings under Section 161.001B Texas Family Code and the order of termination of the respondent's parental rights is not based on evidence precluded from consideration by the court under Section 161.001C Texas Family Code. The court finds it would not be in the best interest of the child to appoint a relative or other person as the managing conservator of the child, and that it would be in the best interest of the child to appoint the department as permanent managing conservator of the child and continue the child in the current placement pending further order of the court. The court finds pursuant to sections 161.2061 and 2062 of the Texas Family Code that it would be in the best interest of the child to grant to the respondent parents limited rights of possession and access to the child as ordered by the court. The court further finds that the court should include in its orders as the post-termination contact the right to monitor that contact during the course of subsequent proceedings in this case, and retain the right to terminate that contact if necessary to protect the best interest of the child. The court will therefore enter the following orders and finds by clear and convincing evidence that they are in the best interest of the child. The parent-child relationship is terminated between the respondent parents and the child. The department is appointed as permanent managing conservator of the child with all the rights and duties of a managing conservator under Texas law. The current placement of the child is approved pending further order to court. Regarding any post-termination contact, the court orders that the respondent will have rights of limited post-termination contact at such times, places, under such circumstances as approved by the court, and with the court and the right to terminate that contact if necessary to protect the best interest of the child. The court will enter a temporary order at this point that authorizes the department to allow the parents to continue to have limited contact with the child to be approved by the department in advance, subject to the court's right to review that and to modify or change it or terminate it if necessary. The department should consult with the child's therapist in conjunction with any visitation that is allowed by the parents, or any recommendations for modifying, changing, or terminating that visitation. But I want to make clear I'm not limiting the court's discretion to change that based on any recommendation of the therapist or to terminate it for that matter. The court will set a permanency hearing after final order on October 4th, 2021 at 3 p.m. Mr. Jett, I'll have a more detailed docket entry that I'll provide to you. I'm going to continue Mr. Harrelson and the guardian ad litem's in the case pending further order of court. And I'll have a more detailed docket entry that'll set forth the findings and orders of the court, Mr. Jett, that you can use to prepare an order of termination. And I'd ask you to prepare that and submit it to the court. Court gives notice to the parties and counsel the right to appeal the court's findings and orders pursuant to section 263.405 Texas Family Code, and of the right to request a de novo hearing before the referring district court pursuant to section 201.015 Texas Family Code. Court gives notice that an appeal in a suit in which termination of the parent-child relationship is sought is governed by the procedures for accelerated appeals in civil cases under the Texas Rules of Appellate Procedure, and that failure to follow the Texas Rules of Appellate Procedure for accelerated appeals may result in a dismissal of the appeal. All right, Mr. Jett, is there any other matters from the department's perspective we need to address for today?
No, Your Honor. Thank you.
Mr. Harrelson, anything else?
No, sir.
Okay, thank you, Mr. Valentino. Mr. House, anything else?
No, sir. Thank you.
Your Honor. Thank you very much.
Thank you. Ms. Jones, I wish you and your family the best of luck. Thank you.